Good afternoon.
Good afternoon, Your Honor.
Good afternoon. Let me get my files in the right place. That's my jury list on that one. Okay, go ahead.
Your Honor, if I may start, on Monday, I raised the issue of double jeopardy because I had already been, the state decided they weren't going to prosecute a case. That was 15 CR 636B. Now, under OCGA section 16-1-8, when prosecution barred by former prosecution, prosecution is for a crime of, B1, prosecution is for a crime of which the accused could have been convicted on the former prosecution, is for a crime for which the accused should have been charged on the former prosecution unless the court ordered a separate trial of such charge, or is for a crime which involves the same conduct, unless each prosecution requires proof of fact not required on the other prosecution. Now, on that issue, the same facts were alleged in that prosecution that are alleged in this prosecution under counts 1 and 2. Now, Patterson v. State, the Supreme Court said, finally and perhaps the greatest importance, the rights conferred on a criminal accused by the double jeopardy clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. To be sure, the double jeopardy clause protects an individual against being twice convicted for the same crime, and that aspect of the right can be fully vindicated on an appeal following final judgment. However, it has long been recognized that the double jeopardy clause protects an individual against more than being subjected to double punishment. It is a guarantee against being twice put to trial for the same offense. Obviously, this aspect of the guarantees protections which would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken. Even if the accused is acquitted or if convicted, has his conviction ultimately reversed on double jeopardy grounds, he has still been forced to endure a trial that the double jeopardy clause was designed to prohibit. If a criminal defendant is to avoid exposure to double jeopardy and thereby enjoy the full protection of the clause, his double jeopardy challenge to the indictment must be reviewable before that subsequent exposure occurs. So I argued on Monday that counts 1 and 2 would amount to double jeopardy, and I have case law citing that even if Your Honor denies my motion to dismiss based on double jeopardy, it's reviewable before the appellate court before a trial can continue.
Your Honor, the state's response would be that he's never been placed under jeopardy for these charges. There was another case for another day that he was out driving in the same truck with the same phone plate, but that was nearly a year after the one that we're actually for trial for today, and that case has been dismissed for other reasons. So I believe that what he's saying is the same conduct is that, yes, he was driving the same truck without a tag, but it was a completely different day of the offense, and he was never tried.
Brief me where I fully understand now. We had on this calendar a case involving a pickup truck. Is that correct?
Yes, Your Honor.
And that case was Norcross at Calico. Is that?
Your Honor, I believe that case, it may have been on this calendar. I know that he had two cases, 15 CR 255B, 15 CR 256B. 255 was null-crossed. We null-crossed that the other day. There was another case on another incident that may have been on the back of the trial calendar. I can't remember if it made it onto this trial calendar or not, but it basically was accused and then null-crossed.
Yes, Your Honor.
Witness availability issues, and that's the one with the pickup truck.
I'm sorry, Your Honor, that one was just last week, I believe. It was now crossed, that was 15 CR 636B. And I do have, these I should. Matter of fact, I have the null cross right here, Your Honor. This was dated on the 13th of October.
All right, let me see that copy of that null cross.
And that's the case that refers to my pickup truck.
All right, what was 255? This is 636B.
255 was, I'm sorry.
Your Honor, 255 was a case where he was riding a motor scooter without a helmet, and I believe wouldn't display his license to an officer.
And that was null cross.
That was what was null-crossed
That
this
was
month.
a helmet violation
Yes, sir, and failure to display the license upon a law enforcement officer.
and motorcycle.
Yes, Your Honor.
All right, 636B involved a personal pickup truck, right?
Yes, Your Honor.
All right, now, we're dealing with, return that to me.
Your Honor, this case deals with two citations that were given about a week apart. The first one was him and his pickup truck.
All right, we're dealing here with 256B.
Yes, Your Honor.
All right, go ahead and explain to me now what.
And this case was combined down in the city of Winder. That's why it's two separate offense dates in one case. So he drove his pickup truck, or the state's alleging that he drove his pickup truck without a registration and a plate back on April 8th of 2014. Then about...
Is this the same pickup truck that we dealt with 636B?
It is, Your Honor. Those two citations are about a year apart, but for the same offense.
Your Honor, I have
But not the same conduct.
Your Honor, I have to object. He's misquoting what the citations
All right, well, I'm
were.
gonna give you another chance, because I'm honestly trying to understand all the facts. What you're saying is that the second of the prosecution that we're dealing with here today involves the same pickup truck, the same absence of a license plate, I assume is what we're dealing with, but it is a totally different set of circumstances. Are you alleging that this was driven on the street, or?
Yes, Your Honor. It was driven, I mean, we're alleging that it was driven on the street on April 8th.
So the act of driving on the street is what you contend is a separate and distinct criminal act, different from those that were previously addressed and either null crossed or otherwise dismissed.
Yes, Your Honor. It was the same truck, same lack of a plate, but different days. And that case never came to trial. It never was placed under jeopardy or anything like that. We dismissed it because of lack of a witness.
Okay, now, you go ahead, Mr. Cooley, and give me your version of it.
Thank you, Your Honor, if I may. And I apologize, I was at the hospital last night, and I've had to take some medication. So my mouth is like getting kind of dry, so every now and then I'll take a drink. On April 8, 2014, the issue wasn't my pickup truck, the issue was with my Kia van. I received a citation for expired tag on my van. Now, with that respect, I'm willing to go to trial on that charge because on April 17, 2014, I received the same type of citation, expired tag, and failure to display license on April 17th. Those two charges I'm alleging double jeopardy on because they contain the same facts as 636B. The facts don't change. The facts was, I was pulled over for an expired tag, and the state is alleging the same facts in this case that they alleged in that case. Regardless of the fact that they...
Well, they helped me by giving me a copy of the accusation. Each of these are accusation cases, and we ought to be able to look at the accusations and tell whether they are alleging the same dates and the same conduct. Do you have that information before you?
Your Honor, I do not have the previous case's accusation. I can provide a copy of the filed accusation, what we're accusing in this case. Do you have the clerk's file, or?
I have the clerk's file in this case. One of the problems is that
We can send someone down to get the clerk's file in the other two cases, just so we have the official record if you like.
well, I think it's essential that we address the accusations, and if they're the same dates and the same conduct, Mr. Cooper may have a point. Mr. Cooper, just have a seat. We're going to get the official clerk's files up here.
Okay, I know I do have them here.